When a defendant is represented by a substitute attorney, is that time excluded under the CPL 3030 Speedy Trial Statute? To find out, you have to read People v. Justice A, but it's 3 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People v. Justice A. The citation for this case is 2023 New York Slip Opinion 05306, published by the New York Court of Appeals on October 19th of 2023. The issue in this case is whether speedy trial time is charged to the people when an alternate attorney, a substitute attorney, appears on behalf of the defendant. The law you have to understand to appreciate the context of this case is that under CPL, Criminal Procedure Law 3030, the people, the prosecution, has a certain amount of time to bring a case to trial from the moment it's filed until the moment that it goes to trial. And if they exceed that period of time allowed by 3030, then it's subject to a motion to dismiss. It can be dismissed on the basis that the people have taken too long to bring the defendant to trial. And that amount of time differs depending on what the charges are. So under, if it's a felony, the people have 6 months. If it's an A misdemeanor, they have 90 days. If it's a B misdemeanor, they have 60 days. If it's a violation, they have 30 days. And so basically at each adjournment, the question arises, who is this adjournment charged to? Is it charged to the defense? There's an unlimited amount of time the defense has, or is it charged to the people? If it's charged to the people and you add it up at the end and it's more than 90 days, then an A misdemeanor must be dismissed. It's that kind of thing. But there are many exceptions to that 3030 chargeable time rule that are found in subdivision 4 of 3030. So, for example, important part for this case is CPL 3030 4F, which says that the time is excluded from being charged to the people if it's time that the defendant is without counsel through no fault of the court, except when the defendant is proceeding as his own attorney with the permission of the court. So the defendant does not have an attorney at an appearance. That time is not charged to the people. Okay, so what are the facts of this case? The facts are that the defendant was charged with an A misdemeanor. So he had 90 days of chargeable time before the prosecution would violate CPL 3030 Speedy Trial Statute. On November 5th of 2018, the case is on trial. This case is on the calendar for trial. The defendant was represented by the Legal Aid Society. 2 things happened on that day, on November 5th, 2018. First, the case was called in the morning, but the defendant was not present in the morning because his lawyer, his Legal Aid Society lawyer, told him, you don't have to come in the morning because the defendant had school. You can come in the afternoon. We'll appear for you in the afternoon. So in the morning, the case is called. The defendant was not there, so the judge issued a bench warrant. The defendant showed up in the afternoon. The warrant was expunged. And instead of his lawyer, his normal lawyer appearing from Legal Aid Society, a different Legal Aid Society attorney showed up and said that the original Legal Aid Society lawyer was leaving the office and that he was going to have to be reassigned a new Legal Aid Society lawyer. That's what the substitute lawyer for that day said. So when the case was then adjourned, the judge said, I'm charging the 8 days to the prosecution. Later on, the defendant made a motion to dismiss under 3030, and that trial judge, that motion judge, decided the motion and calculated all the time, calculated all the time to be 87 days, but excluded that November 5th date from the people. So even though on November 5th, the judge in the courtroom said charge to the people, the motion judge said, I'm not charging this to the people. I'm charging this to the defendant because he didn't have his lawyer. So under 3034F, the time is not charged to the people because it's excluded because the defendant did not have his lawyer. The defendant ultimately appealed this ruling on the 3030 issue. The appellate division affirmed what the trial and motion judge had done. Goes to the Court of Appeals, and here we have the holding. The holding is that 3034F, that exclusion of speedy trial time when the defendant is without counsel, is applicable only, this is the holding, applicable only when the defendant is without counsel through no fault of the court. But that does not exist when there's a substitute counsel. Obviously, they say, here the defendant showed up and had a substitute Legal Aid Society attorney who informed the court that the new Legal Aid Society attorney would be assigned. That person who spoke on behalf of the defendant was a lawyer standing up for the defendant, and therefore he was not without counsel. Because he was not without counsel, that time is not excludable, And because it's not excludable, it's chargeable to the people. And if the motion judge decided there was 87 days and excluded the next 8 days, if you add the 8 days to the 87 days, you're over 90 days. It exceeds the speedy trial time, case dismissed. That's the case of People versus Justice A. Substitute counsel is counsel for purposes of CPL 3034F. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.